Welcome to In the Name of the Law with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinus from Sinus Dramus Law Firm, along with Mary Chartier and Takura Nyemphakusa from Chartier Nyemphakusa PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law. Today we're going to talk about changes of domicile in family law cases, a criminal defense perspective of the Mar-a-Lago search, and an important decision from the Court of Appeals on Michigan no-fault law.
In the name of criminal defense.
On this episode of In the Name of the Law, we're going to talk about how librarians brought to light missing classified documents in the possession of a former president and the search of that former president's home. So in short, we're talking about the FBI search of Mar-a-Lago with criminal defense attorneys Mary Chartier and Takura Nyemphakusa. Welcome back, Mary and Takura.
Thank you, Lisa.
So Takura, for those who may not know, please tell us what happened at Mar-a-Lago.
I'd be happy to. Agents from the Federal Bureau of Investigations executed a search warrant at Mar-a-Lago, which is the residence in Palm Beach, Florida, of the former President Donald Trump. This search warrant that had been executed was authorized by a federal judge, and at issue were some missing documents following a criminal referral from the National Archives and Records Administration, shortened to NARA in some circumstances. And that is the federal agency which is responsible for archiving documents for the government in the United States.
So, Mary, what do we know about the substance of the search warrant that was issued and what the Department of Justice is actually investigating?
At this stage of the investigation, it's really unusual for an affidavit in support of the search warrant to be released, but it was in this case, even though it was heavily redacted. And redaction just means that parts of the affidavit were blacked out, so people can't read them. And what happens is a law enforcement officer goes in front of a judge and swears that this is information that they have. Either someone told them about it, or they've been doing an investigation, or a team of law enforcement officers have done an investigation. And in this case, it supported the search of Mar-a-Lago. So the information in the affidavit would be sources and what they have learned about the documents that were purportedly at Mar-a-Lago. What's interesting is there were 3 offenses that the government was investigating under, and that doesn't mean that charges are going to be brought or this is all that the government was looking at, but they were looking at the illegal destroying of records. And one of the things that they had was surveillance video where boxes were taken from one part of Mar-a-Lago to another. They also were looking at offenses under the Espionage Act. Now for that, it doesn't have to be classified documents. It can just be any documents that would harm the United States. And they were also looking at the improper seizure of the documents or the president or former president keeping the documents when he wasn't allowed to. Those documents belong to the United States government. They don't belong to the president or former president. And so to keep those documents, that is a crime. And that's what the federal government was investigating.
So what do we know about the compositions of the documents that were seized by the government?
So we know that over 11,000 documents were seized. And I want to make sure I get these categories correct. We know that there were 18 marked as top secret, 54 documents marked secret, and 31 were marked confidential. Many of the boxes that these documents were stored in had clothing, items, gifts, things that clearly, well, I should say arguably, should not have been in there, mixed in with, again, the nation's secret documents and even information about other nations. We also know that some of these folders that were marked as classified, 48 of them were empty. They were supposed to go to the Secretary of State or to a military aide. So we don't know what became of these documents.
Okay, so is there a formal process for declassifying these classified documents that were mentioned earlier?
Yes, there is definitely a process for it. There's a code of federal regulations. And one such requirement is that there must be conspicuous markings so that there's no confusion about whether a document is confidential, secret, or any of the other classifications we mentioned earlier.
So Lisa, another important point to mention, and I think we just really want to hit on it, is that there are empty folders and no one knows where those top secret documents are. And there have been concerns about the security at Mar-a-Lago with agents from other governments and other countries coming to Mar-a-Lago under the guise of, wanting to golf there, go to a dinner there, and being found wandering around. So where those top secret documents are, we don't know. And the fact even that a document has been declassified doesn't mean that it doesn't fall under one of the three areas that the government was looking at. So the fact that there were classified documents or whether they're declassified is really irrelevant, because it's still a problem under the Espionage Act to destroy these records, to maintain these records, even if the documents aren't classified.
So something that was really interesting that you brought up, it's not just the fact that they were taken from the White House, but even at Mar-a-Lago, it doesn't sound like it was necessarily a secure location.
No. So classified documents, top secret documents, we both know this from our work. There is a real procedure as to who can view them, where you can view them, how you can view them. First of all, you can't just declassify them in your head. So one of the arguments made initially by the former president was that, he had a standing order to declassify any document that he removed from the Oval Office. There is no standing order that has been revealed. So first of all, if there is a standing order, no one has brought that to light to show anyone. Second of all, even if there was a standing order, and it's highly doubtful that there is, that's not how you declassify documents. You can't just wave a wand or think it in your head and say, okay, well, it's declassified if I take it to Mar-a-Lago, but it's classified at the White House. As Takura talked about, there is a real process. And the agencies that are involved have to be notified about this declassification so that they can weigh in. Because some of the documents there related to human sources. They related to people in our government who are living in other countries who are providing information to us, as well as sources in other governments. It's wildly concerning and dangerous that this information was ever even removed from the White House.
So where does the investigation stand now?
So a senior judge was appointed to serve as the arbiter to review all these documents, these 11,000. And that individual has been given until the 30th of November to go through all of these documents, sift through them, and ultimately decide what happens next. The investigation was paused, and I might note that the judge who made that decision, the criminal aspect of it was appointed by former President Trump just in 2020. So interesting mix of individuals who are involved in that. And that special master being appointed was in response to the former president's attorneys filing a request for that.
What do you think is going to happen next?
Stay tuned, right? This is fascinating. It really is unprecedented. We haven't seen anything like this. Now, the former president is claiming it's unprecedented, and this is a sign that he's being somehow targeted or persecuted. But the reality is there is no former president who has removed this level of documents from the White House. This is just unheard of. And what's really interesting is the government, NARA, as Takura pointed out, they tried to work with his lawyers to get those documents back. So this was certainly not the first move on the part of the federal government. And what's really fascinating is we'll talk about this on later episodes. I know there'll be lots of twists and turns, and we speak about these issues and more on our podcast, Constitutional Defenders. We're on every platform where podcasts are.
Thank you, Mary and Takura.
Thank you, Lisa.
In the Name of Criminal Defense is brought to you by Chartier Niam-Fakusa, PLC. In the Name of Family Law.
Today on In the Name of Family Law, we're going to talk about change of domicile cases. I have with me Jordan Ehlers, who is an attorney, a family law attorney with the Speaker Law Firm, and together she and I have worked on many domicile cases. So Jordan, welcome to the show.
Thank you so much for having me.
You're welcome. And let's talk about what happens in change of domicile cases. So what inspires a motion to change domicile?
I think most often that we've seen, at least in our experience, is that a motion for change of domicile is inspired by some sort of job change, particularly when it's the parent who has primary custody. We have seen it where parents who, they've remarried and their spouse gets another job somewhere. We've also seen that happen, but far and away, the largest reason is that there's some sort of job change for the primary custodial parent.
Now, on the flip side, I think we've seen that maybe the judges aren't necessarily viewing it the same way.
Judges find it, hard to believe that a job change should be enough to remove a child from where they've established their residency. For the most part, I don't know why it is, but that's just what they seem to be doing.
So you mentioned the job change being the impetus a lot of the times. So let's talk about that improvement in the financial situation. How is that relevant to a motion to change domicile?
Yeah, so there's several factors that a court has to look through when, determining whether to grant a change of domicile. And the first factor that they look at is whether the move has the capacity to improve the life of the child and the relocating parents. So that's really where we see, the new job come into play, right? A change in income, particularly if it's an increase in income, definitely has that capacity. It's just whether or not that is enough. And, recently, especially, we've seen courts just saying that it's not enough. There needs to be more than just an increase in the parent's income, or, especially in cases where parents have lost jobs and they find a job somewhere else. Courts just, I don't understand why, but they seem to not be taking it as seriously almost.
Well, a couple of things you said. First of all, the statute says the capacity to improve. And so that doesn't mean that you have to have absolute proof that 100% we know it's going to improve the quality of life, right?
Yeah, for sure. The capacity to improve is actually a pretty low standard, and trial courts don't seem to realize that.
And then the other feature of that factor is that it's improving both the life of the child and the parent. And so I think we've seen a lot of courts really are just looking at the child and not looking at them as a unit, and we're talking about, in a lot of these cases, we're talking about it's the primary physical custodian is the one who's trying to move, the one who has the majority of the parenting time. Do you agree with that?
Yeah, I would say so. I mean, I think I might have seen one or two cases where it's, the parent who doesn't have primary custody, but I think one of the ways that trial courts really, take a misstep, especially at the beginning of these cases, is that they really are only focusing on the child and whether that child's life is going to improve. They're taking that as, the relocating parent has to show that the child's life is most definitely going to improve and, often in a significant way. And that's just not what the statute says.
So let's talk for a second about what kind of evidence would help a parent who is thinking about moving, or they're thinking about trying to get a different job for an increase of pay. What type of evidence do you think might help them make a stronger case to the judge?
So I've seen it where, parents present not only the data associated with their new job, their new salary, their benefits, any additional benefits to the child, but also school data, particularly in the place where the parent is looking to relocate. Crime statistics can also be helpful in terms of how safe the new area is. Just things like that, demographics to show that there are things and, possibilities for this child and this parent in this new location.
So you bring up an interesting point about what the situation's going to be like in the proposed location. And I think we've also seen the appellate courts and even the trial courts wanting to see evidence about comparing it to what their current situation is. So, for example, I remember one case, we compared the crime statistics of where the child was moving to, which was not good, to where they were in a very safe environment. And then also the school situation, it's really important. I remember a case where the mother did a wonderful job of putting on evidence of the great school system this child was going to be in, the opportunities that would be for this child at the new location. But there wasn't evidence about where the child was coming from. So the judge didn't have a basis of comparison for how is that an improvement? Mm-hmm. So to show that it has a capacity to improve, we need to have some sort of baseline of what's happening, right?
Yeah, and I've seen sometimes where parents will include that information in their original motion, but then they don't bring it back up again at the hearing. Mm-hmm. And I think trial judges can sometimes overlook that. So it's really important to, just continually present that baseline and then show how the move has the capacity to improve. That's the key word there, is that we have to remember it's only capacity.
And it's not just financial improvement as well.
Exactly.
So let's just really briefly talk about some of the other factors that courts think about when they're looking to decide one of these motions.
Yeah, so I'd say that one of the factors that, especially if trial courts are, I don't want to say looking to deny, but more inclined to deny a move, is that they look at whether the proposed parenting time schedule that the relocating parent has proposed, whether it's enough to continue to foster the relationship between the child and the non-relocating parent. I would say that that is probably the number one reason that trial judges look to deny these motions, because, you've got a parent and a child who maybe have a really close relationship where they're at right now, where they're having, very regular parenting time, and then a move that's far away where the child would have to travel in order to exercise parenting time, that can look very different.
And what about courts' view on the child being able to talk to the parent on the phone or have FaceTime or Zoom calls with the parent? How is that weighing into the analysis?
I mean, I think that especially in the last 2 years, we've seen in family law where these trial courts are starting to recognize, some of the value that virtual parenting time has. However, in domicile cases, at least in my experience, I've seen that trial judges, I don't know if they're not considering it or if they're just not recognizing it, but they seem to more be concerned about actual physical time that the parent has with this child. Whereas, some parents, if they don't have as close a relationship with their child, that could be replicated via virtual parenting time and then extended parenting time later in the year. It's just whether or not, it's very case dependent. And it definitely depends on what your judge is going to believe and what your judge is not going to believe in terms of how that relationship can continue to grow even from a distance.
Right. So, and we've worked on a lot of different cases. Sometimes we represent, moms that want to move or dads that want the child to stay. And we've done both sides of the coin, I guess. But I think we've observed a trend, and you want to talk about a little bit about the trend we're seeing, and we don't know why the trend exists. Noticed it.
Yeah, I would say that recently, particularly in our office, the cases that we've seen the most is that you have a mother who is the primary physical custodian who wants to relocate, usually for a job change, and then you have a father who maybe doesn't have as close of a relationship with the child, who's not taking advantage of all of his parenting time, who just vehemently opposes this move, like tooth and nail fights this move, and then the trial courts, for whatever reason, are denying the move on the basis of this father who doesn't have much parenting time with the child versus, a mother who, for example, would lose her job and her income and her housing and the child's school enrollment if this move is not granted. And to me, it doesn't make sense to deny the primary physical custodian the opportunity to improve not only their life, but the child's life. And these parents just aren't taking it into account.
Right, and it also obviously is very case dependent because it depends on the age of the child. A young child maybe can't travel as easily as a 12-year-old, for example. So I wish we had more time to talk about the types of mistakes we see trial courts making, but we're out of time. So thank you, Jordan, for joining us today.
Yeah, of course.
Hope to see you back again soon.
I would love to be back anytime you want to have me.
In the Name of Family Law is brought to you by Speaker Law Firm. WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
The Michigan Court of Appeals recently issued a very significant decision regarding Michigan's auto no-fault law. Today we have with us personal injury attorney Steve Sinus of the Sinus Ramos Law Firm and his colleague Lauren Kizel. Now they both worked on this case along with the rest of the firm, and they're going to tell the viewers what this case is all about and how it impacts us.
Thanks for having us. Before we get to the case, I just want to start with an explanation about what happened to the Michigan no-fault law in 2019. The legislature added very significant amendments to how the law works for catastrophically injured people. Prior to the amendments, the original no-fault law said that people catastrophically injured in motor vehicle accidents were entitled to have lifetime care for their injuries under the no-fault system, and that the no-fault insurers would have to pay a reasonable charge for that care. So these people could go to their medical providers and say, I need this service, I need this accommodation, and turn to the no-fault insurer, and the no-fault insurer would have to pay a reasonable charge for that service or accommodation. They could also have their family members be paid for providing them care that they needed in the home, and there weren't limitations on how that benefit was handled. So what was going on in the system is that thousands of people were catastrophically injured in motor vehicle accidents. They were relying on these rights they had under the original law. And then in 2019, when the legislature changed the law, the issue became whether or not those changes would apply to those people who were injured prior to those changes being passed by the legislature, and those people who are relying on the original no-fault law, were their rights now changed as a result of the 2019 amendments. And that is the main issue that was in play in our case, and it's known as the retroactivity issue, whether these new care limitations that were passed in 2019 could be retroactively applied to these catastrophically injured people. And so the case that we handled is known as the Andary case. There were 3 plaintiffs that we represented, and continue to represent, the Andary family, the Kruger family, and a medical provider known as the Eisenhower Center. And the argument in the case is essentially that it's unlawful for these new rules to be applied to our clients because they had their rights under an insurance policy that was sold to them under the original no-fault law. They had been relying on those rights, and that now by imposing the new limitations on their care, such as how much their medical providers get paid, which is a new feature of the law, it's really jeopardizing their ability to access the care that they need. And so we've been arguing in this case that these new limitations on the rate of reimbursement and how family members who provide our clients care, how those new rules apply to people under the amendments do not apply to our clients, and it would be unlawful to do so. And so we filed a case in the Ingham County Circuit Court, and that's where this litigation began.
So, Lauren, what happened in the trial court?
Unfortunately, we lost in the trial court, and the trial court judge held that these amendments could be retroactively applied to individuals who were injured and purchased their policies prior to when the amendments were enacted. But it is important to note that this decision was rendered before a very important case by the Supreme Court was issued. Very important opinion in the Buell case was rendered in 2021, which is a very important retroactivity decision that we are basing a lot of our Andary arguments on.
So does this trial court decision in your case affect other people around the state?
Well, that's what's so unfortunate about what's going on with the chaos that's in the courts over this issue. It was a good thing that the loss that we had in the trial court wasn't applicable to other people injured throughout the state, but what we had was a tremendous state of uncertainty about what the law was. And actually, several circuit courts ruled in such a way where they basically agreed with the arguments we're making in our case, which is that these new rules can't be applied to people injured prior to the effective date of the amendments. So there was no precedential binding effect of our ruling on other people's cases. Meanwhile, other courts were deciding the issue differently, which is why our case at the Court of Appeals became so important to bring more certainty to the law.
So how was the case handled in the Court of Appeals?
So we tried to expedite the case, given that the fee schedules and several of the key things that we were arguing in the case were being implemented in July of 2021. Unfortunately, the Court of Appeals denied our request to expedite, so it proceeded in the ordinary course. The case finally had oral argument on June 7th of 2022 this year before Judges Douglas Shapiro, Jane Markey, and Seema Patel. And again, we focus on the retroactivity issues, arguing that these amendments could not be retroactively applied to individuals who were injured prior to the amendments being enacted.
So what did the Court of Appeals decide?
Ultimately, the Court of Appeals agreed with our arguments and held that there was no indication of intent by the legislature in the amendments to apply these changes retroactively, and even if there was, that would violate the Contracts Clause of the Michigan Constitution.
So let's talk about the significance of the Court of Appeals decision.
So this is a published decision. It means that it is binding on all other trial court cases, which means that other trial court judges do have to follow it for the time being.
So it brings consistency around the state, right?
Correct.
Okay.
In theory, it does. And we can now go into court telling trial court judges, you have to follow the law. Unfortunately, the insurers don't want to abide by the decision, it appears, or at least some don't. And so they're asking trial court judges to stay cases, which is like hitting the pause button on a case, while they try to convince the Michigan Supreme Court to overturn what the Court of Appeals held in our case.
Okay, so what's going to happen in the Michigan Supreme Court?
Well, the insurance companies have filed an application for leave, and the way it works is you have to ask the court to take your case. The court doesn't have to take your case. So we're now in this phase where they're requesting that the court hear the case. We think that even if the Supreme Court happens to agree with the Court of Appeals, they may take the case just because it's such an important issue. So we're now kind of in this waiting game where the Supreme Court has to decide whether it takes the case. And if it takes the case, then it has to hear the case, which, as you know, can take quite some time.
So something I think a little unusual has happened in this case in the Michigan Supreme Court. In my experience as an appellate attorney, the insurance industry has filed what I guess they're calling a motion to stay the precedential effect of the Court of Appeals published opinion. Can you talk to us a little bit about what they're trying to accomplish with that motion?
Basically, the insurance company is trying to get the Court of Appeals Andary decision to not have any precedential value. So essentially that would go back to before the Court of Appeals decision was issued, and trial court judges can decide the case however they want. They don't have to follow the Andary decision.
While the case is still pending in the Michigan Supreme Court, which is really the opposite of what normally happens, isn't that right?
Right.
Yes.
So does that, what happens to all the catastrophically injured people around the state who have basically been living in limbo for the past year or so?
More limbo.
More limbo.
Unfortunately, because the insurance companies don't want to abide by what a published decision says from the Court of Appeals. And I just want to bring the viewers back to the issue at hand, and it's whether or not these people can access the rights they've always had under the insurance policy that they bought from their own insurance company. And what the insurers are arguing is that they have to take away these rights in order to bring down everyone's insurance rates going forward. And that's really what they're putting in these briefs. So when the public thinks about this case, they should think about, is it fair for people to have the rights that they bargained for taken away in the name of trying to lower rates going forward? And one thing the Court of Appeals talked about is that there was no real proof that taking away these people's original rights was necessary to bring down rates. So there's a real issue of fairness at hand here. And unfortunately, in the meantime, not only the insurers not abiding by what's fair, they're also asking the Supreme Court to put a pause button on trial courts applying the law as decided by the Court of Appeals.
So, I mean, not just your clients like the Andary family, but there's a lot of families that have been actively harmed by the decisions that have been rendered regarding the insurance companies' handling of these cases, right?
Yeah, this decision affects thousands of claimants across the state, so it's a very important decision for sure.
Well, thank you for sharing your time with us.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinus Dramus Law Firm.
Thank you for joining us on In the Name of the Law. See you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.
Speaker Law Firm fights for you. When you think all is lost, call us. We are determined, compassionate, and strategic. We are award-winning appellate attorneys. If you are ready to fight on, call us and we'll give you frank advice about your prospects for overturning a trial court's decision. Even if you lost in the trial court, we can help. We understand what appellate judges want, and we apply top-notch research and writing skills to your case that make the difference on appeal. We are your appellate advocates.